If you are issuing or accepting checks against a loan or payment, then you must watch this video. Post-dated checks are used in many transactions. A check bounce is when the bank returns any check unpaid due to the insufficiency of funds in the account of the drawer and many other reasons. Now, what is a drawer and drawee? Legally, the drawer is the one who issues the check, and the one in whose favor the check is issued is the drawee. So the first question comes up: is check bounce a crime? Answer is yes. When a check is bounced for insufficient funds in the bank account, it is a criminal offense. The payee can file a criminal complaint under Section 138 of the NI Act. Next question arises: can an FIR be filed for a check bounce? Again, the answer is yes. You can file an FIR against the person who has issued a check under Section 420 or 106 of IPC in a criminal court. Or the payee can directly file a complaint before the magistrate under Section 138 of the NI Act for a check bounce case after issuing a check bounce notice to the party. Next question is if it is a cognizable offense or not. First, let's see what is cognizable offense. Cognizable offense is discussed under section 154 2C of CRPC, what defines it to be an offense in which the police officer can arrest the convict without a warrant and can start investigation without the due permission of the court. Now, check bounce cases under section 138 of NI Act are non-cognizable. So, a magistrate can take cognizance of an offense of dishonor of checks only on a complaint from the holder in due course, and there is no question of any police investigation. Further, the offense is non-cognizable, so the police cannot arrest without a warrant. Next question is can the drawer get bail if a complaint is filed for the dishonor of a check? Yes. Since the dishonor of a check under section 138 is a bailable offense. Now, what is bailable offense? A bailable offense means that a person can get bail if a complaint is made against him. But in the case where after getting bail a person fails to appear before the court on the specified date, the court can issue a non-bailable warrant against him. The police can arrest the person in case of a non-bailable warrant. Now, can there be both civil and criminal proceedings in case of check bounce? Yes, a civil suit can also be instituted against the drawer to pay the check amount. In the case of institution of a civil suit, the payee cannot issue a check bounce notice. The payee can only issue legal notice for recovery of the amount. Now, a very important question is where to file the case. So, the jurisdiction depends on the place where the payee maintains the bank account. Supreme Court states that as per section 142(2)(a) of the Negotiable Instrument Act, that is NI Act, that if the check is delivered for collection through an account, please note, through an account, the court within whose jurisdiction the branch of the bank where the payee maintains the account is situated will have jurisdiction to try the offense. For example, if I have issued the check to someone and check dishonored, he can file the case within the jurisdiction of the bank where his account is maintained. And section 142(2)(b) states that if the check is presented for payment of the payee or holder in due course otherwise through an account, means not through an account, then the case will be tried by the court within whose the local jurisdiction the branch of the bank of the account of the holder, that is who issued the check, is situated. This provision is made to avoid unnecessary harassment as people go too far places to get the check bounced there. Now come to the next question, that is settlement possible in check bounce cases? The answer is again yes. These cases are compoundable offenses. Now, what are compoundable offenses? Compoundable offenses are those offenses where the complainant, that is one who has filed the case, means the victim, enters into the compromise and agrees to have charges dropped against the accused. It is possible to make settlement out of the court in the check bounce case. After successfully payment of amount, both the parties appear before the court, file the joint memo of settlement to withdraw the case. It is to be noted that these remedies are possible only if the pending debt or liability can be established. For instance, the holder cannot sue the defaulter if bounced check was issued as a gift or say as a donation. Now let's come to the conditions for constituting the offense under section 138. First condition is the check issued by the drawer must have been presented to the bank within the valid period of the check, that is 3 months from the day it was issued. Second condition is if the bank has returned the check unpaid due to some reason, then firstly the payee in the due course of the check must have sent a notice in writing to the drawer demanding to make a payment for the said amount within 30 days, and along with also have sent the receipt of the information regarding the check bounce by the bank. Third condition is even after the notice the drawer has not paid the said amount within 15 days after sending the said notice. Thereafter, within 15 plus 30, that is 45 days from the date of sending the legal notice, case must be filed. In case the case is filed beyond that time, then the case shall be time barred. If the aggrieved party fails to file within this limitation period, the court will not entertain unless the delay is justified with a valid reason. Now let us see what are the trial stages in check bounce case under section 138 of NIE Act. Stage 1 is filing of complaint under section 138 with the court. Then stage 2, that is sworn statement of complaint in which the complainant or his authorized agent should appear in the witness box and provide relevant details for filing the case. If the court is satisfied and finds substance in the complaint, then the summon will be issued to the accused to appear before the court. After that, stage 3, that is appearance of accused. Then stage 4, that is examination in chief. Stage 5 is cross examination. Stage 6 is defense evidence. Stage 7 is arguments, and the last is the judgment. These are important points on check bounce cases. Thanks for watching the video.